life gives you a wonderful coincidence. And the wonderful coincidence this evening is that I've had the pleasure of listening to Senator Sanders describe what happens to a country when billionaires are able to secretly exert immense political power and drive democracy away from its foundations and into the service of the billionaires. And the remarks I'm here to give are about how they do it, the technique for infiltration and influence of our democracy by the billionaires. This is part of my series of scheme speeches about how they have taken over the Supreme Court, captured it in the same way that in the 1800s, big railroads captured the railroad commissions that were supposed to set their rates. They just had their people set the rules for them. It worked great. And we're seeing this with the Supreme Court right now. This is not a conservative Supreme Court. This is a captive Supreme Court, captive to special interests. And the technique that they used for getting there is to hide who they are through an array of front groups. There are dozens of front groups that were involved in the court capture scheme. And the Washington Post did a very good review of them several years ago and calculated, based on what information they could get at the time, that this was a $250 million project, $250 million. Well, the research continued, and folks kept digging. And when I held the hearing about this in my Judiciary Court Subcommittee, the number had climbed to $400 million spent on the court capture enterprise. And they've kept digging, and now it turns out that the number is over $580 million. Over $500 million was spent in this effort to capture and control the United States Supreme Court. I don't think you spend over $580 million unless you have a purpose. And very often the purpose is to make that much money back and more. And there's a web of front groups that are used to deploy all that money. And this is just a part of that web. This is just one sort of combined creature in that web. So let me take a few minutes and just go through the different organs and limbs of this creature. The center of it is a pair of organizations, the 85 Fund and the Concord Fund. The way that extremely wealthy people play in politics these days is to put two organizations together that they establish under the tax code. One is called a 501c3, which is named after the section of the tax code under which it's established. And the 501c3 gives you two wonderful things if you're fiddling in politics. One, it gives you anonymity. You don't have to disclose your donors. And two, it gives you a tax deduction. You get to write off the money that you give to manipulate the American public. But you can't do something very important with a 501c3. You can't go out and manipulate public opinion. You can't participate in elections. So when you do that, you need to have something else called a 501c4, the very next provision in the IRS code. So you take your 501c3 and you take your 501c4 and you set them both up. In my view, there is usually no real distinction between the two. There's a doctrine in law called piercing the corporate veil that separates separate corporate entities, that allows people trying to pursue usually damages to show that this is a fake corporate division. You pierce the corporate veil. The 501c3s and 501c4s are a corporate veil that you could probably pierce with a banana. They have the same locations. They have the same mailing address. They have the same staff. They have the same board members. They have the same funders. It's essentially the same organization, but it just operates under two legal structures. So that's what you have for starters. You've got your twinned front groups. The 85 Fund is your 501c3, and the Concord Fund is your 501c4, and they're essentially the same creature. But in this case, this organism has other limbs. So what you can do under Virginia corporate law is, if you're the 85 Fund or the Concord Fund, you can file with the corporate registry of the state of Virginia permission to operate under what is called a fictitious name. So you can operate under your own name, 85 Fund, or you can file with permission a fictitious name. I'm not making that up. That is actually the word in Virginia law, a fictitious name. Well, the 85 Fund filed for permission to operate under the fictitious name of the Judicial Education Project, the 501c3 that takes in money and tax deductibly to work on the capture of the court. And on the other side over here, the Concord Fund, your twinned 501c4, has its own twinned fictitious name. So the Judicial Education Project has its own little twin in the Judicial Crisis Network. Well, what do we know about the Judicial Crisis Network? We know that it took checks for as much as $17 million from secret donors, and it used that money. Imagine writing a $15 million check to an organization like this. It took that money, and it first ran campaigns to attack Merrick Garland, to round up Republican support for opposing him as a Supreme Court justice. And then when that was successful, and they brought on Judge Gorsuch, in came other big checks. And then when Gorsuch was on the court and it was time for Kavanaugh, other big checks. And then it was time for Amy Coney Barrett, other big checks. We've counted 4 checks over $15 million, which means probably someone, could be 4 separate individuals, but it was happening so regularly, you think you'd probably go back to the same source. Somebody spent probably $60 million to control who got onto the United States Supreme Court. And we don't know what business that $60 million donor had before the court. But it's not unusual for cases before the court to have outcomes that will shift way more than $60 million. Just the climate change cases move hundreds of billions of dollars around, protecting fossil fuels' enormous subsidy. So you have your 85 Fund and Concord Fund pierce the corporate veil with a banana pear, and then you have their fictitious twins, Judicial Education Project and Judicial Crisis Network, with big money flowing in. But it's not enough just to pack the court. You also want to make sure that you're suppressing voters. Voter suppression is a very big deal. So you set up your Honest Elections Project to do voter suppression, because in this weird billionaire-funded parallel universe, everything has the opposite name of what it is. And over here you have, on the 501c4 side, your Honest Elections Project Action, because there you can spend some of the money politically. So you've got a whole separate set of twins, this time completely fictitious twins, fictitious names, no different from 85 Fund and Concord Fund, designed to go out in the world and suppress voting. Bring lawsuits, write challenge letters, argue for new laws. And then, as we saw in Virginia recently, you can really whip people up about what's going on in schools, critical race theory. So you set up your free-to-learn fictitious name with its little twin, free-to-learn action, to do the 501c4 political work. So now what you have is a total of 8 organizations that are really the same. Who does this? Who in real life does this? Sets up 8 organizations, 6 of which are mere fictitious names, to run the same money from the same donors out in the world, to make it look as if something real is happening, when in fact the whole thing is a phony front. And then you have up at the head of the critter, you've got how the people behind it get themselves paid. So you have advisors who advise these various entities. You've got this CRC Advisors is the name of the group. It's got its public relations antenna here, and it's got its strategic advice antenna here, and the money flows usually this way, so that the people who run this scheme for the big donors can take their cut. They get paid here. These are all for-profit. These are all the not-for-profits that are set up because they allow you to hide who your donors are. So that's the rig that was set up. And this is not the entirety of the front group scheme that was funded by the $580 million. This is just one coordinated corporate critter that was set up in order to perform all of these different several functions. Think back to the Founding Fathers and their desire to set up a democracy where people made choices about their governments, where popular democracy would be the way in which society went forward. You think they had in mind something as creepy and complex as this? And do you think all that effort to build all this scheming, all the lawyers to file all the papers, to cook up all the funny fictitious names, to create all these bogus organizations, what's the point of all that? Could there be a legitimate point to that? Why all the shells? Why all the hiding if you're not up to no good? Well, the bottom line is they're up to no good. And the no good is to capture the United States Supreme Court and turn it from a proper court into a captive political entity that will do what the people who are behind all this money tell it to do. And there are many ways they do it, and I'll go into those many ways on other occasions. But on this one occasion, I wanted just to focus on this multi-faced corporate creature that hides its donors, that does all of this different work through fake, fictitious name organizations, and through which money gets extracted by those who run it so that they can pay themselves for this vast disservice to democracy. To be continued. I yield the floor.
The senator from Rhode Island.
Ask for its first reading.
The clerk will read the title of the bill for the first time.
H.R. 5376, an act to provide for reconciliation pursuant to Title II of S.Conras 14.
I now ask for a second reading, and in order to place the bill on the calendar under the provisions of Rule 14, I object to my own request.
The objection is heard. The bill will be read for the second time on the next legislative day.
I ask unanimous consent that the Senate proceed to executive session to consider the following nominations en bloc, calendar numbers 1098 and 1099, that the Senate vote on the nominations en bloc without intervening action or debate. The motions to reconsider be considered made and laid upon the table, that the President be immediately notified of the Senate's action, and the Senate resume legislative session.
Without objection. The question occurs on the nominations en bloc. All those in favor say aye.
Aye.
All opposed, no. The ayes appear to have it. The ayes do have it. The nominations are confirmed en bloc.
I ask unanimous consent the Senate proceed to the immediate consideration of H.R. 5313, which was received from the House and is at the desk.
The clerk will report.
H.R. 5313, an act to protect children and other consumers against hazards associated with the accidental ingestion of button, cell, or coin batteries, and so forth, and for other purposes.
Without objection, the Senate will proceed.
I further ask that the bill be considered read a third time and passed, and the motion to reconsider be considered made and laid upon the table with no intervening action or debate.
Without objection.
I ask unanimous consent that the Help Committee be discharged and the Senate proceed to the immediate consideration of S. 734.
The clerk will report.
S. 734, a bill to amend the Child Abuse Prevention and Treatment Act, and so forth.
Without objection, the committee is discharged, and the Senate will proceed.
I ask unanimous consent that the Hassan for Cornyn amendment be considered and agreed to, and that the bill be considered read a third time.
Without objection.
I know of no further debate on the bill as amended.
If there's no further debate, the question is on the bill as amended. All those in favor say aye.
Aye.
All those no. The ayes appear to have it. The ayes do have it. The bill as amended is passed.
I ask unanimous consent that the motions to reconsider be considered made and laid upon the table.
Without objection.
I ask unanimous consent the Senate proceed to the consideration of Senate Resolution 738 submitted earlier today.
The clerk will report.
SRS 738, recognizing the importance of trademarks in the economy and the role of trademarks in protecting consumer safety, and so forth.
Without objection, the Senate will proceed.
I know of no further debate on the resolution.
Is there further debate? If not, all in favor say aye.
Aye.
All opposed, no. The ayes appear to have it. The ayes do have it. The resolution is agreed to.
I ask unanimous consent that the preamble be agreed to and the motions to reconsider be considered made and laid upon the table with no intervening action or debate.
Without objection.
I now ask unanimous consent the Senate proceed to the immediate consideration of SRS 739, which was submitted earlier today.
The clerk will report.
SRS 739, authorizing the printing with illustrations of a document entitled Committee on Appropriations, United States Senate, 1867 to 2022.
Without objection, the Senate will proceed.
I further ask that the resolution be agreed to and the motion to reconsider be considered made and laid upon the table with no intervening action or debate.
Without objection.
I ask unanimous consent that when the Senate completes its business today, it adjourn until 12 noon on Wednesday, August 3rd, and that following the prayer and pledge, the morning hour be deemed expired, the journal of proceedings be approved to date, the time for the two leaders be reserved for their use later in the day, and the Senate be in a period of morning business for debate only until 1:30 p.m., with senators permitted to speak therein for up to 10 minutes each. Further, that the order with respect to Treaty Document 1173 be modified to reflect the following, with all previous provisions remaining in effect. Sullivan Amendment number 5192 and Paul Amendment number 5191.
Without objection.
For the information of the Senate, there will be up to 3 roll call votes at approximately 4:30 p.m. in relation to the NATO treaty. If there is no further business to come before the Senate, I ask that it stand adjourned under the previous order following the remarks of Senator Portman.
Without objection.